All right, hello everyone, and welcome to our latest ALTA Insights webinar. I'm Jeremy Yohe, Alta's Vice President of Communications, and today we've got a great presentation that's going to dig into the Federal Trade Commission's final rule that bans most non-compete agreements nationwide. The rule faces some challenges in several courts, as you'll learn about during the presentation. But as of now, it is set to go into effect September 4th. So thanks for joining us today and learning more about the requirements. Before starting, I've got a few housekeeping items to go over. Today's webinar is being recorded. You'll get an email with a link to the recording tomorrow, and you can always access all of our webinar recordings at alta.org/webinars. In the meantime, you can download a PDF of the presentation from the handouts section in the GoToWebinar window pane. If at any time you have a question or comment, submit them through the questions box. We'll hold some time at the end for Q&A. I need to thank SoftPro for sponsoring today's webinar. And before introducing today's speaker, here's a short message from SoftPro. Well, maybe if I can click the right button.
With SoftPro, our staff is much happier than they were. Our retention rates are through the roof, and we are delivering the best closing product that we have ever had.
I don't know of any other program that works as well as SoftPro does. The efficiency, user-friendly especially, and then definitely, again, the customer service.
All right. Thank you, SoftPro, for that message. Let me move a few things here on my screen, and we would introduce today's speaker. There we go. All right. Well, we're fortunate to have Risa Borner with us today. Risa is a partner of the law firm Fisher & Phillips. Risa regularly litigates and counsels clients on issues pertaining to the hiring and termination of employees, compliance with employment discrimination laws, negotiating and drafting employment agreements, covenants not to compete, confidentiality agreements, employee rating, unfair competition, and related matters. She's assisted clients in drafting and updating existing employment agreements and implementing local and nationwide policies for protecting trade secrets and proprietary information. Risa, that's a great deal of experience in the employment side of things. So thank you for joining us today and sharing your analysis of the non-compete rule that does impact the title insurance industry. So welcome.
Thank you, Jeremy, for that introduction. For those of you who don't know Fisher Phillips, we are a nationwide labor and employment law firm. We have over 600 lawyers in 38 offices across the country. I'm based in Philadelphia, and you can see in my screen on this side that I'm not only a partner at Fisher Phillips, but also the resident champion and winner of our NCAA men's basketball pool. So that is my trophy until next spring. Thank you very much, Jeremy. And I'm glad you were able to join me today to talk about the FTC's non-compete rule. So we're going to talk to.
Risa, sorry, I know some of the attendees, I believe, are in the Philly area. So Risa is in Philadelphia. So any other, oh wait, I don't know if you're an Eagles fan, maybe not an Eagles fan, but I know I see some Eagle fans out there. So.
Sure, Eagles, Phillies, we're a great sports town. Absolutely. So we're going to talk today about several things relating to the non-compete rule. The agenda is on the slide. We're going to start, or the next slide, we're going to start with the background on the non-compete rule. And just to give you a little context to start, when we're talking about the non-compete rule, non-compete agreements generally are agreements that say that an employee can't go work for a competitor for a certain period of time, usually in a certain geographic region. So it's really preventing somebody from taking employment. We'll talk a little bit about the FTC's definition of non-compete, but that's really just practical terms, that's what a non-compete is, an agreement that prevents you from taking a position. And that's in contrast to other common terms that you find in restrictive covenant agreements. So for instance, non-solicitation provisions are different. A customer non-solicitation provision might prevent an employee from soliciting a customer to go work for a competitor. An employee non-solicitation covenant might prevent an employee from soliciting coworkers to leave your company or go work for a competitor. All those are all different, and still different is an NDA, non-disclosure agreement, or confidentiality provision, also very common in restrictive covenants. But those types of provisions, non-solicitation provisions and NDAs, those are not directly covered by the rule. So I'll talk about how they might be implicated indirectly on one of the later slides, but just for context to start with, that's the difference between a non-compete and other types of covenants. So we'll talk about the background of the rule. We'll talk about the features of the rule. There are some limited exceptions to the FTC's non-compete ban, and I'll walk through what those are and how they apply. Some are not as straightforward as they might seem from the terminology. We'll talk about the status of legal challenges to the rule. You may have seen there have been multiple lawsuits filed to try to prevent the FTC from being able to enforce this rule. So I'll talk about where those stand and what we might expect going forward. And then finally, we'll talk about what you should be doing as an employer to try to comply, first of all, with the FTC's non-compete rule, but also to prepare to protect your trade secrets and confidential information if the rule remains in effect and is not enjoined. So starting with background, the first bullet here talks about media attention. So I wanted to start by talking about how we got here. Why is the FTC targeting non-competes, and where did this come from? And really, I think it started around 2015. There was a famous sandwich chain across the country that was having its employees, its sandwich makers in particular, sign non-compete agreements, preventing them from going to work for other sandwich companies if they were to leave. And I like to say to employers who use non-competes, they ruined it for everybody because they got a ton of media attention after being sued by a couple of employees who were sandwich makers for asking courts to declare that the non-competes were not enforceable. And then a couple of state attorney generals got in on the act, and they filed separate lawsuits, again seeking a declaration that those non-competes for the sandwich maker were unenforceable. This just got an enormous amount of media attention, as I mentioned, and I think it got the ball rolling a bit in terms of federal action on non-competes, because the following year, in October of 2016, then President Obama called on states to ban most non-competes. And he said it would lead to more competitive labor market and faster wage growth. So he planted the seed for what ended up occurring, during this administration. So, that I think is how the focus on non-competes really functionally started. There is state legislation. Non-competes have really been regulated mainly up to this point at the state level, not at the federal level. The FTC's non-compete rule is really the first federal regulation that would apply throughout the United States. Up to this point, states were the ones that decided whether non-competes were enforceable, whether there were going to be any limitations on the use of non-competes, and there were a number of existing laws relating to that. Now, there were, as you see in this bullet, there are existing bans on most non-competes in California and North Dakota and Oklahoma for quite some time now. Non-competes have been banned with some limited exceptions. Minnesota got in on the act about a year or so ago and banned non-competes as well, again with some limited exceptions. Other states have not banned non-competes, but have restricted their use. So, those restrictions mainly fall into two categories. One is that some states have required that employers provide notice to employees in certain ways and at certain time intervals in order for the non-compete to be effective. So, for instance, in Illinois, you have to give 14 days for an employee to review the non-compete. Colorado has a very specific notice requirement. You have to provide a separate notice form to the employee. It has to be signed by the employee, and it has to be separate from other documents they might be giving them. So a number of states have notice requirements. They're not all identical, but they mainly follow along those lines. And then some states have set income floors or wage thresholds, saying an employee who makes under a certain amount cannot be given a non-compete, or some say hourly employees can't be given a non-compete. Those types of things. New York almost passed, or came very close last year to passing a complete ban on non-competes. It would have been the strictest in the country. Both houses of the New York legislature passed this bill, and then at the 11th hour, the governor of New York decided not to sign it after very heavy lobbying against it. And so I think New York, if the FTC ban does not take effect, I think New York probably will revisit this and come up with some alternative that is less than what was proposed. But those are some examples of what we've seen from the states. Now, getting to current day and how we ended up with the FTC non-compete rule, President Biden made a request earlier in his administration to the FTC and directed them to exercise their statutory rulemaking authority under the FTC Act to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. So moving to the next slide, this led in January 2023 to the FTC issuing a proposed rule that banned most non-competes. And so they put out the proposal and it called for comments, and it received over 26,000 comments in response to the proposed rule. So it took over a year to review all those comments and publish the final rule, which came out earlier this year in April. And so the final rule bans most non-competes. It's largely the same as the proposed rule with a couple of exceptions, including in the sale of business context. And I'll talk about that and the other exceptions in more detail in just a little bit. And as Jeremy mentioned, there will be a September 4th effective date for the FTC's non-compete rule unless a court stays the rule before that. So now we come to the definition of a non-compete clause. I gave you just a very general, plain terms description of what a non-compete clause is, but the FTC has given this definition that is on the slide, which is more wordy, but it's significant because it really has three components. It says you have a non-compete if you have an agreement that prohibits a worker from, that's one, two, penalizes a worker for, or three, functions to prevent a worker from seeking or accepting work in the US with a different person where the work would begin after the conclusion of employment. That includes the term or condition, or operating a business in the US after the conclusion of employment. That includes the term or condition. So you can't operate your own business. That's a competitor. You can't go work for someone else who is a competitor under the rule. But these different categories, prohibiting a worker, penalizing a worker, and functioning to prevent a worker, those are no accident. The FTC published about 500 pages of commentary together with the rule. And in there is an explanation of why they did that. They want to avoid, they said, having employers create agreements that might not be titled non-compete, but that functionally are the equivalent. So they give some examples of things that they consider to be functionally the equivalent. We do have some slides on that coming up, but I'll give you a for instance, since we're talking about it now. For instance, forfeiture for competition provisions, like for instance, you have to give back this bonus or this equity award that you received if you go work for a competitor. The FTC has come out and said that the FTC would consider those to be non-competes. So even if you don't title it a non-compete, it can function to prevent a worker from taking a position or penalize a worker and still be considered a non-compete. A few details about the non-compete rule. It covers independent contractors, not just employees. It actually covers more than that as well, although most employers that I talk to don't use non-competes, for instance, with summer interns or part-time workers, anybody who works for you, whether they're paid or even if they're unpaid, they can't have a non-compete. So, but for most of the companies that I work with, the material distinction is employees and independent contractors. They both are covered in addition to other types of workers. The rule has retroactive effect. And what I mean by that is if you have a non-compete that's signed before September 4th, it cannot be enforced after September 4th. So you don't have your non-competes grandfathered in. Just because they were signed before September 4th does not mean that they're going to be able to be enforced after September 4th. The opposite is true, unless they're subject to an exception, which again, we're going to talk about in a minute. Now, I guess we'll talk about it right now because it's on this slide. The exceptions include exceptions for senior executives, which have a very particular definition that we're going to talk about on the next slide, and also sale of business agreements. Again, they have a very specific definition as well. And notably, between the initial publication of the proposed rule in 2023 and the final rule in 2024, one thing that the FTC did change is the amount of ownership that would need to be required in order to qualify for the sale of business exception. Initially, the FTC was going to set a very high bar for that. I think it was 25% ownership interest. And in the final rule, the FTC said, no, we're not going to set a threshold amount of ownership interest. If you're an owner, even if you own a small percent, you could still qualify for this exception. And again, I'll talk in a little more detail about how the sale of business exception works in a few minutes. The non-compete rule does not apply in all contexts. So there are some excluded entities, mainly because the FTC doesn't have authority over all businesses. So for instance, if a nonprofit would not be covered by the non-compete rule. Federally regulated banks, credit unions, and financial advisors also not covered. And it does not apply to a franchisee in the context of a franchisor or franchisee relationship. So what that means is a franchisor and a franchisee can have an agreement with one another where, let's say, the franchisee cannot compete with the franchisor, but that does not mean that the employees of a franchisee can have non-competes. It just means the franchisee itself, like the franchise owner, can have a non-compete. So senior executive, I had mentioned earlier on in the presentation that some of the exclusions to the rule are deceptively complicated. And I really was thinking about this one when I said that. So you hear the term senior executive and you might think, okay, our senior managers or anyone who is a director of a business unit, or you might naturally think those are people who would be considered senior executives. But the FTC gives a definition that is relatively limited for senior executives. So it says a senior executive is a worker who was in a policymaking position and received total annual compensation of at least $151,164 in the preceding year. And that's either actual or annualized. So if they worked for part of the year, you'd annualize that amount. Policymaking position itself has a definition under the rule. And so and that's on the next slide. So that definition is a business entity's president, CEO, or the equivalent, any other officer of a business entity who has policymaking authority, or any other natural person who has policymaking authority for the business entity, similar to an officer with policymaking authority. So you might be guessing this, but yes, policymaking authority has its own definition. Before I get to that on the next slide though, there is a little more to the definition as well. A policymaking position is defined as well as an officer of a subsidiary or affiliate of a business entity that's part of a common enterprise who has policymaking authority for the common enterprise may be deemed to have a policymaking position. But the FTC goes on to exclude some employees. So they say, if you don't have policymaking authority over the common enterprise, meaning, so if you're a business that has multiple units, multiple subsidiaries, if the person doesn't have policymaking authority over the common enterprise, the whole business, then they may not be deemed to have a policymaking position, even if they have policymaking authority over a subsidiary or an affiliate of a business entity that's part of the common enterprise. So I think that this is not intuitive. You know, you hear the term senior executive and you might think the president of our subsidiary, of course, would be a senior executive, but the FTC seems to be making a distinction. And you know, this is where they've drawn the line on that. They also further explain it, and on the next slide, by defining policymaking authority itself. So what does that mean? Another person who has policymaking authority. Well, they say that means final authority to make policy decisions that control significant aspects of a business entity or a common enterprise. And again, they do not include authority limited to advising or exerting influence over those policy decisions. So I'll pause on that. So if you make recommendations to someone, but you do not have authority to make the final decision, the FTC seems to be saying that would not be policymaking authority. Or if you have final authority to make policy decisions, but only for a subsidiary of or an affiliate of a common enterprise. Again, they're saying, well, that's not policymaking authority for, you know, under the meaning of the rule. So if you're scratching your head at this point and saying, well, then who is this? Who is a senior executive? Then you are like so many of my clients that I work with who are trying to figure out where to draw the line and what makes logical sense based on these definitions. It really is not crystal clear. And, you know, certainly it would seem they mentioned CEOs and, you know, presidents. You'd think that would be safe. Probably other members of the C-suite as well. Beyond that, I think you need to look at the individual, what their role is and what authority they have, what decision-making authority they have in order to answer whether or not that person is a senior executive. The good news is that the rule does provide a good faith exception. So if you make the wrong decision, if you made it on good faith, then the FTC says you will not be deemed to have engaged in an unfair method of competition, which is, you know, if you violate the FTC rule, that is the consequence. You're deemed to have engaged in an unfair method of competition. But again, they say, look, if you made a good faith decision, even if it turns out to be wrong, you will not be deemed to have engaged in an unfair method of competition. So if you draw the line in the wrong place, but you have a good basis to argue that it was reasonable, then presumably you would not be in violation of the rule. So the other exception that I mentioned is for sale of a business. The rule does not apply to a non-compete clause that's entered into by someone pursuant to a bona fide sale of a business entity, of the person's ownership interest in the business entity, or of all or substantially all of a business entity's operating assets. So this too was very intentional phrasing, rather than just saying sale of a business. And again, in the 500 pages or so that accompanied this rule, the FTC does talk about why. And they say they don't want employers to easily be able to evade the final rule by engaging in certain conduct. You know, and in particular, they say, well, you know, springing non-competes, which are non-competes where a worker has to agree at the time of hiring to a non-compete in the event of some future sale, those they say are not going to qualify as a sale of business non-compete. Or sham transactions between wholly owned subsidiaries. The FTC specifically says those are not bona fide sales because they're not made between two independent parties. So the FTC envisioned, based on the commentary, that there might be some clever ways that employers might try to get around the rule by claiming that there was a sale of a business. You know, maybe issuing stock, you know, to an employee and saying, well, you know, this was a sale of some ownership interest. So the FTC specifically said, look, to be a bona fide sale, it has to be one that's made between two independent parties at arm's length, in which the seller has a reasonable opportunity to negotiate the terms of the sale, and you know, not one of these other things that I've described. And they say that that's because workers don't have goodwill that they're exchanging for a non-compete, or knowledge of, or the ability to negotiate the terms or conditions of a sale at the time of contracting in these other situations where a company might be issuing stock or something like that, and then claiming it's a sale of business.
Teresa, real quick question on this topic before we move on. Bailey asked, you know, what if the business wasn't sold but acquired and now just operates under a different LLC name.
So not sold but acquired. So if it's not sold, are we talking about like an asset? We're not talking about an asset purchase, or are we talking about just a rebranding? Does it say? I'll answer
Just
both.
Rebranding.
No, I don't think a rebrand would be considered. This is my opinion based on what I've seen in the FTC's commentary. I suspect the FTC would say that that is not a sale of business because it's not between two independent parties at arm's length. They seem to be saying, you know, if it's all within under the umbrella of the same company and you're shifting ownership within the company, then that would not be a sale of business. And I think likewise, rebranding a business unit that you already own likely is not going to be considered a sale of business. But I don't believe they comment on different types of acquisitions, an asset purchase versus a stock purchase. I think you could argue either one could possibly be a sale of business, you know, under the circumstances. I just think a rebrand, that would be a tougher argument.
Okay, thank you.
Sure. So I talked a little bit before about non-solicits and NDAs, and I'm going to come back to that now. So I had mentioned at the top that generally non-solicitation provisions and NDAs or confidentiality provisions, those are not prohibited by the non-compete rule. But the FTC does say that they could be considered to be the functional equivalent of a non-compete depending on how they're drafted. So if they're drafted in a way that the FTC would interpret as preventing or functioning to prevent a worker from seeking or accepting other work or starting a new business, then the FTC says, well, then we're going to treat it as a non-compete. So, you know, what does that mean? They give some examples. They're not especially helpful because some of them are very extreme and unusual in my experience, but I'll give you a couple of those examples. So in the context of NDAs, you might be thinking, how could a confidentiality provision be considered a non-compete? Well, the FTC gives a couple of examples where they think it might be. So they say, you know, they saw an NDA that barred a worker from disclosing in a future job any information that's usable in or relates to the industry in which the employee works. Not confidential information of the business or of the employer, but any information usable in the industry, regardless of where they got it, whether they got it while working for the company or not. They can't use any information relating to the industry. The FTC says that could be a functional non-compete. Most employers I work with don't draft their agreements to cover information that an employee received outside of the course of their employment, you know, which seems to be what the FTC is suggesting here, but that is one example that they provide. Also, they say an NDA that bars a worker from disclosing any information or knowledge that the worker might obtain during their employment whatsoever, including publicly available information, that too might be the functional equivalent of a non-compete. Now, there's an interesting drafting note, I think, to be had here. You know, if you're considering, you know, how might I shore up my confidentiality provisions and my agreements to avoid the possibility that the FTC would say that they're a functional non-compete. The FTC does say an NDA would not be a non-compete, and this is on the slide, so if you get copies of the slides, you can copy this language, where the NDA's prohibitions on disclosure do not apply to information that first arises from the worker's general training, knowledge, skill, or experience gained on the job or otherwise, or two, is readily ascertainable to other employers or the general public. So just unpacking that, you know, what does it mean to say it arises from the worker's general training, knowledge, skill, or experience? Well, generally, most states have lines of case law that say you can't prevent somebody from using general skills they've picked up over the years, you know, not necessarily based on confidential information or unique training that you provided, but just things they've picked up over time generally, you know, not confidential information, that you can't prevent a worker from using that. You can't say, hey, you're trained as, you know, as a mechanic, and we employed you for 2 years as a mechanic, so now you can never go work as a mechanic again. unless you taught the employee something very special or unique or confidential. Generally, most states would not allow you to bar the employee from just using their general knowledge and experience as a mechanic that they might have gained over a number of years, not based on anything confidential you taught them. So that's really what this first prong is intended to address, that you're not trying to tell someone that they can't use their general knowledge or general training or general skill or experience. And the second, I think, is fairly self-explanatory. If it's readily ascertainable to other employers or the general public, meaning it's already out in the public. Let's say you publish a list of your customers, on your website. This is an extreme example, but you can't have an NDA probably that says, well, you can't share the names of our clients if they're already published, maybe by you, on your website. So the FTC is saying, look, if your NDA excludes these things, then it's probably not going to be considered a non-compete. So for drafting, as I mentioned, if you wrote this into your confidentiality provision or an NDA and said, look, this doesn't apply to your general training, knowledge, skill, or experience, or information that's readily ascertainable, then it's not going to be considered confidential. The FTC is saying, well, that probably would not be considered a functional non-compete. A couple of other gray areas that are not resolved by the FTC, and they specifically decline to resolve them in their materials, are non-acceptance and no hire provisions. So what I mean by that is maybe a brand of non-solicitation provision says you not only can't you solicit our customers when you leave, but you also can't accept any work from them. So even if they contact you and say, hey, I want to work with you, and you haven't solicited them at all, you might have a contract that says you can't accept that work. The FTC does not weigh in these materials on whether those would be considered a non-compete or not. Same thing with no hire provisions. I mentioned employee non-solicitation, not being able to solicit a coworker. Well, sometimes those are written to say not only that you can't solicit a coworker to leave, but also you can't hire them. Maybe even if you haven't solicited them at all and they just contact you. Some employers write it that way. Again, the FTC does not weigh in on whether or not that would be considered a non-compete. So we don't know what position they would take. I suspect that some provisions like that, if the FTC rule is upheld, will make their way through the courts with people arguing on both sides. So, I mentioned earlier that there were some other types of provisions that don't use the word non-compete that the FTC calls out as possibly or likely being functional equivalents of non-compete. So I'm going to mention a couple of them here. I talked about forfeiture for competition already. Liquidated damages, the FTC says, well, if you have a term that penalizes, meaning it imposes a penalty on an employee for going to work for a competitor, that could be a non-compete as well. So they give an example. They say, well, look, if you have a term that provides that for 2 years after the worker's employment ends, they can't engage in any business within a certain area that competes with the employer unless they pay liquidated damages of $50,000, that would be considered a non-compete. So even if you just call it liquidated damages provision, it's not the title that's necessarily going to make the difference. It's the substance. And that's one example of a type of provision that the FTC says it would likely consider a non-compete. The FTC also talks about severance arrangements and says, well, if you have a severance agreement, let's say with an employee you're separating from your business, and you say that they're going to be paid a certain amount, but only if they refrain from competing, the FTC says, well, that would be an example of a provision that penalizes a worker. So the FTC would likely consider that as well to be a non-compete. Another one that is talked about by the FTC in its commentary to the rule is garden leave clauses. So there's a rich history with garden leave clauses. They're often used in the UK. What a traditional garden leave clause looks like is you say to an employee, look, for this period of time, let's say a year after you leave, you're not allowed to work for an employer. And during that time, we're going to pay you. Usually it's a pro rata amount over the course of a year. You get a certain amount every month. The FTC has said, well, some types of garden leave provisions will be non-competes and some won't. And so the distinction is, if you are still going to employ the worker, so you're not terminating them and then paying them, but you're still keeping them on your payroll, they're still your employee, and they're going to receive the same total annual compensation and benefits on a pro rata basis, that would not be a non-compete clause. That's a valid garden leave clause. That's not a non-compete because it's not a post-employment restriction. So they're drawing the line at, they have to stay employed by you. That's not, then it's not a post-employment restriction, then it's a during employment restriction. And in case you're wondering, the non-compete rule does not invalidate during employment non-competes. So if you have agreements with your employees that say, while you're working for us, you can't go work for a competitor, they're not impacted by the FTC's non-compete rule. It's only post-employment restrictions that are implicated. And there's another example that the FTC gives that's on this slide as well, where a worker doesn't meet a condition to earn a particular aspect of their expected compensation, like prerequisite for a bonus. The commission would still consider the arrangement garden leave. That's not a non-compete clause, even if the employer didn't pay the bonus or other expected compensation. So what that means is, if you have a discretionary bonus program and it's in your discretion whether to give the bonus or not, that you don't have to pay that to the employee during the garden leave period in order for it to be a valid garden leave provision. Only non-discretionary compensation would be included. So if you're guaranteeing certain bonuses and without discretion for meeting certain thresholds, for instance, then the employee would have to be paid if it's non-discretionary. So it's based on the worker's earnings over the preceding year, when the term total annual compensation is looking back over that year at what the employee earned, and that's what you have to pay them during the garden leave period. It includes salary, commissions as well. If you have a commission, employees who are paid on commissions, again, non-discretionary bonuses, and other non-discretionary comp that's earned during that 52-week period. It does not include board, lodging, other facilities, payments for medical insurance, payments for life insurance, contributions to retirement plans, or the cost of other similar fringe benefits. I'll do two more. There are two more as well. TRAPs. TRAPs are training repayment agreement provisions. They're not categorically banned. And the FTC says essentially you got to look at each one to figure out whether or not it would be considered a non-compete, but the FTC specifically declined to say that they're categorically banned. So it gives a couple of examples. In the interest of time, I won't read them out loud, but they are on the slide if you want to look at them, of what might be considered a trap that could be considered a non-compete. And then bonus repayment provisions. The FTC says these are okay as long as they're not tied to working for a competitor. So if you say that the employee has to repay the bonus if they leave, but you don't say you have to repay it if you leave to go work for a competitor, then it's okay. So again, it can't be tied to going to work for a competitor, just, but if it's not, and if you just say if you leave to go anywhere, competitor or not, you have to repay this, then it's okay. It's not a non-compete. So I'm going to talk about notice requirements next. So if you're wondering, okay, what do I have to do to comply with this rule, assuming that none of the legal challenges change anything between now and September 4th? Well, by September 4th, you have to send a notice. It's got to be clear and conspicuous, and it has to notify the worker that their non-compete will not be and cannot legally be enforced. So you need to identify who entered into the non-compete clause with the worker. So what that means is you have to name your company. ABC company is notifying you, and it has to be delivered in one of these different methods. By hand, I've yet to speak to an employer that's actually going to deliver these by hand, but if you're a small business and you have everyone in the office, you could do that. Or you can deliver it by mail to the last known personal street address, by email to an address belonging to the worker. So not to their new work address, but to an address that belongs to the worker, or by text message. Actually, I'm sorry, I was conflating personal street address with email address. Let me restate that. You can send it to their home address, it doesn't say work address, or you can send it to an email that belongs to the worker that does include their current work email or a personal email address. And then again, as I was saying, by text message at a mobile phone number. You can do it by you only need to do one method of transmission, not multiple methods of transmission. So you can pick one of these and send it by these. The FTC has issued guidance to small businesses that adds a little clarity to this as well. One of the things the FTC said is you can send a group email or mass email to your current employees who've signed non-competes to notify them about the rule. You do not have to send individual separate emails to each of those employees. The notices do have to go, though, both to current employees and to former employees who are still subject to a non-compete. So if you have a 12-month non-compete, anyone who signed one who's left in the last 12 months would also need to get the notice. Now, if they signed a non-compete but they're outside of the notice period, you do not have to send them a notice. The FTC published model language for the notice. And they say if you use that model language, then you have a safe harbor. Essentially, you're deemed to be in compliance with the rule. So I've included that model language in this slide, and you can see there are a couple of bits of information you need to insert. But if you use the form, again, the FTC says it's a safe harbor and you're deemed to be compliant. Now, I'll just add to that. This form, if you use it, it's really important to identify the people who are excluded if you're going to use this form, because you'll see the form does not say this doesn't apply to senior executives. So for instance, if you give this to your senior executives, it might create confusion or some legal disputes over whether or not, whether or not you advise the person that their non-compete's not enforceable. So you want to, if you're going to use this form, you want to make sure you identify who should not receive the notice and make sure they don't get that notice. Also in the sale of business context, if an owner of a business you acquired signed a non-compete, the FTC rule does not apply to them. Now, it does apply to employees of that business owner. So just to be clear, when I talk about the sale of business exception, that only applies to people who had an ownership interest in the business. It does not apply to their employees. Their employees still, under the FTC rule, their non-competes are not enforceable. And for senior executives, one thing I want to clarify, I don't know that I mentioned it already. A senior executive who signs a non-compete before September 4th, their non-compete is still enforceable by you after September 4th, but you cannot ask them to sign a new non-compete starting September 4th. So the exception only applies to senior executives who sign non-competes before September 4th, but it does not give you the right to ask senior executives to sign non-competes starting on or after September 4th. That's different than the sale of business exception, because the sale of business exception for owners or co-owners of a business, you still can ask them to sign a non-compete after September 4th. So you want to make sure you're not giving the notice to people to whom it doesn't apply. The rule also doesn't apply where there's a cause of action relating to a non-compete clause that accrued before the effective date of the rule. So if someone violated their non-compete on September 3rd, you can still sue them on September 5th because that cause of action accrued before the effective date of the rule. So that's another exception that we hadn't talked about yet. All right, so what about state laws? What does the FTC rule do to state laws? Well, it supersedes them if they're less favorable to employees. So if you live in a state that says that non-competes are enforceable, then the FTC rule would supersede that. Your state law would no longer apply. But it doesn't affect state laws that are more favorable to employees. So if you live in a state, for instance, that bans customer non-solicitation provisions, the FTC rule doesn't displace that if there are provisions of the law that are more favorable to employees, only if they're less favorable. All right. Now we come to legal challenges to the rule. So what are the legal challenges and where do they stand? This slide talks about the arguments that were made by the dissenting commissioners. So this was not a uniform decision of the FTC to issue the non-compete rule. There were dissenting commissioners, and they argued several things, that the FTC lacked authority to engage in unfair methods of competition rulemaking. They said, based on a 2021 case, West Virginia versus the EPA, that went up to the Supreme Court, where the Supreme Court ruled that that the EPA lacked authority to issue certain regulations. They said, well, the FTC lacks clear congressional authorization to undertake this initiative, the non-compete rule, and that even if the FTC had authority for making the rulemaking, it's still an impermissible delegation of legislative authority under the non-delegation doctrine. So those are the legal bases. But what are the cases and where are they? So there are 3 pending lawsuits. The first was filed by a company called Ryan LLC, which is a global tax services and software provider, and that was filed in federal court in the Northern District of Texas. They filed just a hair before the U.S. Chamber of Commerce filed its own separate lawsuit in another Texas court. That other court stayed that case, and ultimately the U.S. Chamber of Commerce intervened in Ryan LLC's case, effectively becoming a party to that case, and the Chamber of Commerce's own lawsuit was dismissed without prejudice. So there's only one lawsuit pending in Texas right now, and it's the Ryan LLC case. So that court was deciding a motion for preliminary injunction, so temporary relief to stop the FTC from being able to proceed with the rule. And it issued a decision on July 3rd. And what it said essentially was the FTC lacks authority to engage in this rulemaking. And it also said, but it was going to issue an injunction limited only to the parties in that case. So Ryan LLC, the U.S. Chamber of Commerce, and the other interveners, the FTC cannot enforce the rule against them based on this temporary injunction. But the court specifically declined to issue a nationwide injunction. So it declined to apply this ruling to other employers. Some of our clients have been confused about this because there was another very well publicized decision on a different employment related issue in Texas right around the same time, where the court issued an injunction limited to all Texas employers, but not outside of Texas. That's not this case. That's not what this case did. So if you're in that boat, which some of our clients were, where you're thinking, if I'm in Texas, then this applies to me, that's not true. The injunction only applies to the parties in the case, which was very frustrating to many who were hoping that the court would issue a nationwide injunction, because the reasoning for the decision theoretically could apply to all employers across the country, but in practice, the court did not do that. So the court is going to rule on a pending motion for permanent injunction. It has said that it will issue that decision by August 30th. The court could change its mind at that point, and it could do one of several things. It could grant the nationwide injunction, and it could make it apply to all employers. It could make the existing injunction permanent and only relating to the parties in the case and nobody else. Or it could dissolve the injunction. I think that's highly unlikely. I don't think the court's going to change its mind about the FTC's authority, but it's a possibility. So on August 30th, we'll know more. I suspect the court will not rule before then. The problem for employers is that August 30th is the Friday before Labor Day. Labor Day is September 2nd. The rule goes into effect September 4th. So for many of the companies that I'm working with, it's just not practical to wait until then to be able to plan to send your notices. So many of the companies that I'm talking to are planning now what they're going to do, who they're going to send notices to, what those notices are going to say, because you may not get a decision until 1 or 2 business days before you have to send the notice. ATS Tree Services, that's a different case in Pennsylvania. The court declined to issue any injunction in that case. So, and its reasoning was the exact opposite, really, of the Texas case. It found that the FTC does have authority to issue this rule. So that case is not going to stop. It looks highly unlikely to give any relief that would stop the FTC from being able to enforce this rule. And the last pending case is Properties of the Villages versus the FTC. That's in the Middle District of Florida. That case was filed about 2 months after these other cases. Again, the parties have filed a motion for an injunction to stop the FTC from being able to implement this rule and enforce it. It's fully briefed, and just today the court had a hearing on the motions. We don't know when they're going to rule, but the briefing is closed. The hearing will be over today, so the court could rule at any time. And yes, it's possible that the court could grant a nationwide injunction in that case. So we'll have to stay tuned. We just don't know exactly when that decision will come out. It only takes one district court judge anywhere in the country to issue an injunction that's nationwide to stop the FTC, at least temporarily, from being able to implement and enforce the rule. Whatever the outcome of these cases, I do expect that there will be appeals, and the appeals will take some time to work their way up through the courts. This may go all the way up to the US Supreme Court. Some of you may be familiar with the recent US Supreme Court decision in the Chevron case, and you might be wondering, like, how is that going to impact the decisions here? Yes, I do think that it's relevant, and in fact, in the Ryan LLC case, the Chevron decision had come out just a couple of days before the opinion was issued, and the court, although it didn't heavily rely on it, it did mention it in the context of the ruling. I think, not giving deference to agency decisions, I mean, I think that, in my opinion, it's relevant to whether or not the FTC has authority to issue this rule. And I do think that ultimately that will be invoked at some point in the courts, whether it's at the district court level or the appellate court level. Moving on, I know we're running short on time, but these last couple of slides, I'm going to skip impact on existing claims and pending litigation. I just reiterate and clarify, if you have a case that's pending, this doesn't preclude you from continuing with it. Because the FTC said where cause of action relating to a non-compete clause accrued prior to the effective date, as I mentioned, then it's not precluded by the rule. And the slide gives some examples of some recent cases that took into account or didn't take into account the FTC rule in issuing or denying injunctions. So recommended action, if you're an employer listening, what should you be doing? You should be developing a personalized strategy right now. And what I mean by that is, as I said, figure out who are you going to notify if you need to comply with the September 4th notice date requirement under the FTC rule. And who are you not? Who are your senior executives who might have, if anyone, might have signed one of the non-competes in the sale of business context, so that you know who you have to send a notice to. And then think about, how are you going to send the notice? Do you have email addresses? Can you send it by email? Is that feasible for your current employees? Identify former employees who might be subject to non-compete still within the non-compete period. And do we have working emails, for instance, for them? Or are we going to have to mail the notices? Some of my clients, not a lot, but I have some who are using text messages. They have text messaging systems where they can blast out multiple texts at once. Are you going to send it that way? But you want to make sure you have a strategy, because you may end up not getting a decision until late in the day, the Friday before Labor Day, leaving you with 2 business days to get the notices out. And then think about also, what are you going to do if you do use non-competes? What are you going to do with your agreement starting September 4th? The rule does not allow you to ask employees starting September 4th to sign non-competes other than in the sale of business context. If you have agreements with non-competes, start thinking about, well, gee, when, as a practical matter, do we need to amend these? Or, what are we going to do? And keep monitoring legal developments, because there could be a decision out of Florida before then. There could be a decision on August 30th. We don't know, but there could be some decision between now and then that suspends the enforcement of the FTC rule. And then finally, consider alternatives. Look at your agreements, make sure that you have strong, tight agreements that protect your trade secrets, protect your confidential information, that you have strong practices to protect that information. Don't disclose, for instance, confidential information to people who don't need to know it. Don't make it available to everyone at your business if you don't need to. Just look at ways to enhance the protections for the information that you have. and look at your customer non-solicitation provisions, your employee non-solicitation provisions, and figure out, whether or not there's anything that you need to do to enhance the protections or to strengthen them in case the FTC rule takes effect. So I think we have a couple more minutes. Jeremy, I don't know if we have any questions that I haven't addressed.
Yeah, thanks, Risa. We do have a few questions that have come in. We got a few minutes, so we'll pitch them to you. Great information on helping companies, get ready, be ready to comply with the rule if nothing stops the train from rolling. I should have mentioned this at the top of the webinar that today's presentation is for educational purposes only. You should seek legal counsel for specific guidance. Let's see here, a few rolling in here. You touched on Chevron already. There was another question to follow up about the sale of business. What if a business is sold and an employee's stock agreement is bought out by the acquiring entity?
If the employee isn't an owner of the business, then they're not going to be able to be covered by a non-compete.
Okay, all right, pretty clear there. This question is kind of a protection of under an NDA. I think the slide when you're talking about training, if you have an employee and you've hired them for one job, you've trained them for something else, and they didn't have these skills before you hired them, are you protected under an NDA?
If you have provided them with training that's confidential, I was speaking to a client yesterday who has very specialized equipment in their manufacturing facilities that was built especially for the company. Nobody has the designs outside of the company for that equipment. They don't really know. Nobody outside the company would know how it works. And some employees on the manufacturing floor would have the information to be able to say to a competitor, hey, there's a different or better way to do this. You can have an NDA that protects that kind of information. So in answer, if you have training that relates to confidential business methods, you share confidential information during the course of the training, yes, you can protect that. But what you can't do is say you can't go work for a competitor. So you can't have a non-compete, but you could have a confidentiality provision that could potentially protect that information.
Okay. Yeah, the question, got specific about the title industry. If you hired them as a didn't say what you hired them as, but then you trained them on how to be an examiner or a closer. Yeah, so, all right.
Sure. Yeah, yes, if it's confidential. If it's not confidential, there's no confidential information, there's no trade secret, you would not still be able to have a non-compete. So you wouldn't be able to have them go, you wouldn't be able to say categorically you can't go work for a competitor in either area, really, whether it's the current one or the former one. But you could draft your confidentiality provision if there's confidential information to cover that.
Okay. A question come in as you work with your clients and maybe they're moving away from non-competes. What are some other options that you're seeing out there in the field?
Yeah, depending on your financial resources and how important or valuable the employee is to you. Garden leave provisions or even notice provisions. I've seen some employers considering notice provisions. You have to give 30 days notice, before you go work for a competitor, or not a competitor, I'm sorry, before you leave. You shouldn't say before you go work for a competitor, but if you have to give 30 days notice before you leave the company. There's nothing that says that you can't have that. As long as the employee remains employed, it's not a post-employment restriction. So that's one way around it, but then you have to keep paying the person. So you might, you might put them on administrative leave and they're not actually doing anything productive for you and you're paying them during that period of time. But that's the most direct corollary to a non-compete. Other protections include what I mentioned earlier in terms of non-solicits and confidentiality provisions. But the closest thing to a non-compete without being a non-compete is either a notice provision where you keep employing the person during the notice period, or a garden leave provision where you keep employing and paying them the same way they were being paid.
Okay. All right. Thank you, Risa. All right. We are at the top of the hour. If we didn't get to your question, Risa's contact information is there on the slide. Just know she knows how to pick basketball winners out there, so be leery. Anyway, if you missed parts of today's webinar, or if you think others in your office would benefit from listening, as I mentioned, a recording of the presentation will be available at alta.org/webinars, and you'll also get an email with a link to the recording tomorrow. I do need to thank SoftPro once again for sponsoring today's webinar. And with that, that will bring us to the conclusion of today's presentation. Risa, thank you again for joining us and sharing your expertise.
Thank you very much for having me.
All right, take care, everyone.